a seller materially breaches a real estate contract, then the buyer may not have to continue performing the buyer's contractual obligation, and the buyer is going to first want to consider whether the buyer still wants to buy that property or whether the buyer wants to sue the seller. If the buyer no longer wants the property, then if the seller materially breached, then the buyer could potentially just walk away from the transaction and cancel it and get their escrow deposit back. If the buyer still wants the property, then the buyer can allow the seller an opportunity to cure the breach. But if the seller won't cure the breach, then the buyer may have to sue the seller. In some contracts, they may require that mediation take place before a lawsuit is filed. So in that case, the buyer and the seller will need to mediate. And if the dispute is still not resolved, then the buyer can consider suing the seller, and the buyer can sue the seller for specific performance to force the seller to sell the property to the buyer, or the buyer may be able to sue the seller for money damages.